Friday, February 8th, 2019. This is a rule development workshop for Rule 34-18.001. My name is Graydon Schaefer. I'm a senior attorney for the Florida Commission on Ethics. This workshop is being recorded. If you haven't, please sign in on the sign-in sheet being passed around. I think all of you have. We ask you include your contact information, but I do want to advise you Florida has a broad public records law. So written communications to or from state officials or state personnel regarding state business, they constitute public records and they are available to the public and the media upon request, unless the information is subject to a specific statutory exemption. If you don't want your email address released in response to a public records request, just don't list it or send any electronic mail to us. Instead, contact us by phone or in writing other than email. And we can be telephoned here at the Ethics Commission at 850-488-7864. I'd like to note the Florida Department of State has an electronic rulemaking system, which is an electronic internet program that allows you to register and receive emails whenever a rule development notice is published regarding a rule in which you're interested. It also allows you to make online comments to proposed rules. But I want to note the notice of proposed rule hasn't been published yet on the rule that we'll be discussing today, so I don't believe that feature will be available to you yet on the Department of State website. The purpose of this workshop is to begin addressing the language in the recent amendment found in Article 2, Section 8H2 of the Florida Constitution. The amendment prohibits public officers and/or public employees from abusing their public positions to obtain a disproportionate benefit for themselves, or for their spouses, children, or employers, or for any business in which they contract or serve as an officer, partner, director, or proprietor, or in which they own an interest. The amendment requires the Florida Commission on Ethics, in accord with the statutory procedures governing rulemaking, to define the term disproportionate benefit and to prescribe the requisite intent for finding a violation of that new prohibition. The amendment gives the Commission until October 1st of 2019 to complete the rulemaking process. So, to accomplish that, the Commission published on December 5th of last year on the Florida Administrative Register a notice of development of rulemaking. The notice stated the Commission will be holding 3 workshops to assist in the rule development process. This is the second of those notice workshops. It should be noted that there's no preliminary text or draft of the rule available yet. The purpose of these workshops is to help develop a draft rule that will be noticed and presented to the Commission at a meeting later this year. The specific meeting at which this presentation will be made to the Commission has not yet been determined. At this point, we're just asking for your thoughts and feedback as we start preparing a draft of the proposed rule to present to the Commission. Now, all written comments submitted prior to or during this workshop will be made part of the record. We've had some proposed language submitted to us by Mr. Slay, Mr. Atkins, as well as by Cheryl. I made copies of their proposals. You're free to take one. I think that Cheryl dropped one off too. I don't know her last name.
Stewart.
Cheryl Stewart. I'm sorry. At least I got the first name
You're
right.
good. We're good.
Sorry.
No problem. It's all works, right? I've been calling up.
Oral comments will also be taken during this workshop. After you're recognized, I just ask you clearly announce your name and the organization or any that you're with, if you're with any, and then just limit your comments solely to the rule which you're going to be developing at this time. And that concludes my introductory comments. We'll now proceed with the workshop on Rule 34-18.001. I open the floor now to anyone who'd like to be heard regarding the definition of the term disproportionate benefit and prescribing the requisite intent for finding a violation of that prohibition set forth in the new constitutional amendment. So the floor is open for comment.
I'll go ahead and start it. A little speak here, if you'll just bear with me. Good morning, everybody. My name is Carlos Slay. I live in Callahan, Florida, and I'm a citizen here today to speak on this bill, on this amendment of 12. And Florida is faced with a crisis in public trust in its public office holders, and the Commission on Ethics is the public body charged with responsibility to ensure that the trust is restored. The reason this disproportionate benefit language is in the constitutional amendment, as I see, it is because it is commonly known that the current process is broken and does not work in a fair and unbiased manner for the average citizen. The commission must ask itself questions like, is there a disproportionate benefit when a public officer holds a title as business manager for his wife's business and pursues no bid contracts with elected school boards? Is there a disproportionate benefit obtained when the public officer's spouse company has no real prior experience, but the elected official has a close relationship with her husband and award a no-bid contract? Is there a disproportionate benefit obtained when a company lobbies for passage of a special appropriations and the appropriation fails in a normal budget process and then secretly hides the exact same project inside a state university budget on separate lines, only to reappear after the budget is passed and the university awards the contract to the spouse of the public official who has close ties to a state senator? Is there a disproportionate benefit obtained when the local state attorney refers to the Inspector General at Florida State University a request to investigate how the money was used for the controversial selfie project, and the audits finds there remains $169,000 still missing, but makes no referrals to any agency in response? Is there a disproportionate benefit obtained when the Commission on Ethics interviews a state senator to ensure it has clarification of his testimony, but will only interview a citizen once before allowing the public official to assert claims extracted from newspapers that were never part of a complaint filed with the commission? Do you believe that the investigator has provided the public official a disproportionate benefit that they are then able to gain from over the citizen? Should the citizen be given the same ability to clarify when the public officer seeks to muddy the waters by asserting new counterclaims? Does this provide a disproportionate benefit to the public officer? And last, I would like to ask the commission in this rule proceeding, act in the broad public interest of restoring public trust and take under consideration the proposed rule language that I am submitting today. And thank y'all for listening.
Thank you, Mr. Slang.
Can I ask just a couple questions? Sure. Because you're going through those fast and I'm trying to process. It sounds like a lot of them are issues relating to let me just broad terms, contracting, right?
Mm-hmm.
I'm just in my head, I think categories. So there's some contracting, and then another one that seemed to deal with a lot of legislative. Tell me more about the legislative pieces that you had there.
The legislative is when you use your friends. Let's use your friends, any position of the state as a senator.
Okay.
Special language is being used to help push that process of your business, of doing business and receiving funds from the state when it gets turned down in the House. But your friend, as an elected official, both of you are, use those positions in your office to push it further.
Is it the senator or is it the person? I just want to understand.
So-
It is both.
Both, it's both people.
So
Okay,
you're
that's all my question.
you're familiar with the controversial secret appropriations that were going through the universities?
Only what I read in the paper, for the
Right.
UCF thing?
Well,
That's
through
the only one I know about.
FSU, they had like $1 million,
Okay, this one I know.
went through FSU,
Okay,
landed in our county, into the hands of the tax collector's wife's company, who had
Okay.
virtually no experience.
okay.
It then translates into an experimental program to do testing on kids in the public schools under no contract, which essentially you could go buy these tablet tests. 500 tests cost $2,000, okay? The state of Florida ends up spending, hundreds of thousands of dollars
It was like a line
under a
item
no
in the budget
bid,
or something.
under a no bid arrangement.
Okay.
And of course, the reality is that you still have $169,000 missing. And so the reality of it is that the is there a disproportionate benefit? So the question then becomes is, and this is what gives me heartburn.
Sure.
And what gives me heartburn as a citizen, then, and again, if you want people to play by the rules, you have to decide, the Ethics Commission is the final line. That's where the line in the sand is. And if that line is compromised, I think as Mr. Slay has pointed out, the reality is when people don't trust this process works, if it's broken, well, everybody gives up. Now you have chaos. Because the reality is that when you can stop this process from working, and it is, no one's going to come to you and going to report to you and say, look, I'm going to file this complaint. And then literally, when you can put a chilling effect on complaints being filed, because the process is so irreparably broken, which is, personally my belief, it's so broken. Why would anybody in their right mind, I told Mr. Schaefer this, why would anybody in their right mind file a complaint with your commission? No one should. No one should file a complaint with your commission, Ms. Doss, period, okay? And the reason why they shouldn't is because the process is broken. Your investigative process is broken. Your process is fundamentally unfair to the citizens. It doesn't function. And so,
Mr. Atkins,
so-
could we
so
get
the
back
truth
to
is-
the rule that you're
Sure.
proposing? And could you
So the
maybe-
truth is that what you have to,
Okay.
what you have to focus on is what is a disproportionate benefit. So when you look at examples, for instance, there was when you looked at the issue of a disproportionate benefit, when you have the executive director of the FWC providing an affidavit essentially saying, this undercover law enforcement boat belongs to the FWC. And then I inquire, because I'm so concerned about, hey, he just disclosed an undercover law enforcement boat. I inquire of FWC's general counsel. In fact, I filed a complaint against the general counsel. Reality is, after investigation, the colonel of the FWC says that wasn't an undercover law enforcement boat, never was.
Mr. Atkins, like I said at
So-
the start, we need to
Hold on.
confine our comments just to the rule that we're
So,
trying to define.
truth is that a disproportionate benefit? So these are questions, this is part of testimony, Mr. Schaefer, certainly I hope you would appreciate what testimony's about. Testimony is about asking the question, what is a disproportionate benefit? So until the commission can understand what a disproportionate benefit is or is not, I think that's what we're talking about, aren't we? We're talking about what is and what is not a disproportionate benefit. So in my proposed definition, a disproportionate benefit clearly is a special benefit. It has to be defined. The commission has to look and examine whether or not there was, through official conduct, the agreement or cooperation of state, local, governmental, contracted entities of any type of a special benefit for the public officer, public employee, the employer of the public officer, their family members, because let's face it, you guys passed out an advisory opinion that in my view created a disproportionate benefit to the superintendent of our public schools in Nassau County, that essentially said to her, you are cleared to go to have your stepson have contract with your stepson to provide all the roofing contracting that they want to do, because you've granted them a disproportionate benefit through protection of that advisory opinion. That's a safe harbor. So the question is that advisory opinion a disproportionate benefit? Would that qualify as a disproportionate benefit? I personally believe under this constitutional amendment, it is. Because it would certainly rise to that threshold, and certainly you have to look at that when you have a superintendent of schools asking her counsel to send to you a letter saying, hey, by the way, keep my name out of this, I don't want my name disclosed. That should be your first clue. As executive director, I would have rejected that letter and said, listen, we're not going to accept that. But the bottom line is that you guys responded. You provided a favorable opinion because they knew the word stepchild is not defined. It's a defect in the law. It's a defect in the law. It's still a defect in the law. And so the reality is now you have a safe harbor. So the superintendent can contract with the stepchild that can run throughout the state of Florida. You now create a safe harbor for that disproportionate benefit to exist. That was a mistake, in my view, as a citizen, as a taxpayer. Somebody pays school board taxes. I don't think that's creates fairness in terms of how superintendents should not be contracting with stepchildren for the purpose, because I think it excludes that competitive bid process, which I think is so very, very valuable to the fiscal interest of the taxpayer, of the ratepayers at the local level. And I think it's in the interest of everybody to make sure competitive bid process works the way the legislative intent language of 287.001 prescribes. And
Mr. Atkins, can I ask you just a quick question about your definition here?
I'm still providing testimony, Mr. Schaefer, but you know,
Oh,
if.
great,
if-
let's just,
If we're going to
Mr.
listen.
Atkins, whatever you would like to say,
Very
you
good.
go right ahead and say it, and you just let us know when you're done.
Well, I mean, if you would like to testify, Ms. Doss, I guess.
No, we're here to receive
I
information and
understand.
feedback from you.
As I said,
I mean,
the
within-
citizens are a dying
Right.
breed in this
And
country.
I don't wanna shut you down, but, you know, just so that we can have a logical flow of the meeting, and I want everybody else to be able
Sure.
to say their piece too, but go ahead and make whatever statement you can, you know,
I
within the
understand.
bounds of reasonable.
Sure, absolutely,
So, go
absolutely.
ahead.
You know, so from my perspective, I think, you know, certainly, the commission certainly should give great weight to the notion that, you know, the special benefit that is derived from the acts, the omissions, the failure to act in the broad public interest. There's a duty, an obligation, and when you seek to hold a public office, whether it is serving on a community development district, okay, which I know is now a new brand, a new breed of public official that is now serving, you know, homeowners. I mean, homeowners are also being represented by community development districts, okay? These are also public officers these days. You know, whether you're being represented by a county commissioner, there are obligations, there is a duty, there is an obligation to represent these individuals. So we have to define and have clearly iterated in the minds of the commissioners, in the minds of the commission, what is a disproportionate benefit? When has a disproportionate benefit been granted? When has a disproportionate, and it's really kind of hard to see that from the perspective, other than the perspective of the citizen, the taxpayer, the people that are on the receiving end of what is happening. Because the reason why this was voted with the energy, enthusiasm, and the significance that it was, is because people really do know it's broken. They know it. They know it, they see it, they understand it, and they feel it. Because they really feel that the system upon which is being imposed upon them is unfair. And unfortunately, it doesn't work for them. It works for the special interest, it works for the people that are well connected, it works for the people that have great influence. So the influential class, the special interest class, the elected class, it all works well for them. But unfortunately for the average citizen, who might seek to say, look, you know, we want this country to work in a fair and unbiased way, and we want everybody treated equally, unfortunately, it doesn't work well for them. So when you look at the examples of what disproportionate benefit might look like, then I think it's important to understand what those examples might appear like. And I think there's examples of that. And so I think it's important to understand what those examples, and some of those examples might be uncomfortable to talk about. But again, but they're there. They're there, and it's hard to walk back from those, because people walk themselves into it. Nobody asked them to walk themselves into it. And so I think, you know, when the state attorney, as Mr. Slay pointed out, you know, made a referral to the, you know, Florida State University and said, hey, I want you to go look into this. Also made the same referral to the Commission on Ethics to go look into this. Commission on Ethics, you know, there was absolutely no response from. But the, you know, Florida State University did look into it, conducted an investigation, found there's $169,000 of public funds unaccounted for, and there's no follow-up, no referral from them. Is that a disproportionate benefit? I don't know what the answer to that is, but there's $169,000 unaccounted for, and so from the from the public's perspective, certainly we should ask the question, is it a disproportionate benefit? Did somebody gain improperly from that or not? Should we be concerned about that or not? And so from my perspective, I think the term special benefit becomes important. I think the special benefit, as it relates to no bid contracts, set aside agreements, memorandum of agreements, other types of similar contractual legal instruments that obligate, bind state agencies, local government, quasi-governmental entities, special legislative appropriations do not open to, particularly when they're not open to competitive bid. And I think competitive bid is important. So if you're a public official, I think it's okay for you to participate in the competitive bid process. And if you can prove up your competitiveness in the competitive bid process, then I think that's incredibly fair. I think there's no problem with that. Because I don't think there's any special benefit that is inherently involved. And so in terms of treating the public official fairly, listen, my wife was a public official. She served honorably for 18 years. And I can tell you it was an incredibly difficult period of time in my family's life to have to work through those 18 years. But I can tell you she did it. She did it with great honor and great integrity, but the reality is having to steer clear of that problem was a constant weight on her mind. It's not a weight on everybody's mind, but certainly it is something that you have to pay attention to when and where that happens. So being able to have an opportunity to be competitive and to participate in the competitive bid process, I think is fair and reasonable. I also think, certainly if there is examples of pattern of conduct, I think that's when a probable cause investigation should happen. I also think there should be substantial and competent evidence. I think that should be the evidentiary standard. I think that should be clearly the evidentiary standard that demonstrates the public officer sought to seek the disproportionate benefit on behalf of himself or others. And I think if he's involved in a company, they should have at least 10% or more ownership. Less than that, I don't think it's significant to the public interest. So I think, again, you have to have balance in this process. I think less than that, I think it's an insignificant, I don't think it rises to the level of significance that, that you should be given that much weight. Again, I think probable cause investigation should arise when you have you shall commence evidence that there's that at least will attempt to gain that special benefit. So I believe that there are examples that we should look towards, and I think some of those examples might include some of these types of situations that have arisen. And I just know that the response I got from FWC is they advised the executive director of FWC not to sign an affidavit, that it was not indicated. General counsel told them not to do that. Clearly, the Ethics Commission investigator could have clearly found out everything I found out. One call was all it took. Did that affidavit provide a disproportionate benefit to the person, to the public officer? Absolutely it did. So the question is that something a state agency head should be doing? Probably not. Based upon the recommendation of the general counsel to the state agency head, should not have been signing an affidavit. Did that provide a disproportionate benefit? We should look at and say yay or nay. If it's not, it's not. If it is, it is. And we should draw some sort of reasonable conclusion about those types of things, because that's what gets complicated. That gets very complicated. So upon closer examination, here you got general counsel. General counsel telling an agency head, don't sign that affidavit. The affidavit was created by the public officer while they're under investigation by the Ethics Commission. They're drafting the affidavit for the state agency head to sign. And so you have general counsel of the state agency telling them not to sign it. You have the law enforcement director of the state agency saying that's not an undercover law enforcement vote. All this information was easily obtained. So the reality is that a disproportionate benefit? The Ethics Commission relied on that information, okay, in order to come to conclusions. And so my sense is in restoring the process to an even footing, in terms of encouraging people to participate in the Ethics Commission's process, to be involved in the Ethics Commission process, to have faith in this process, that it's going to work in a fair and equitable way, I think you have to have some sort of, there has to be some sort of sense that it is fair, that it's not weighted in favor of the elected class, or it's not weighted in favor of those influentials or the ones that are, the ones that really have an ability to participate in this. So I think that's what we have to sort of look at. We have to look at the examples and say, upon what basis does the definition or examples of disproportionate benefit play out? And what is a disproportionate benefit? And I think that's the nature of testimony. I think that's the nature of what the hearing's about. And with that, certainly I'd be happy to answer any questions you may have.
Thank you, Mr. Atkins. Does anybody else want to speak to their drafts or to any other topic?
Should I? Should we go? Yeah, okay, so, in a slightly different, approach, and maybe that's just we're all learners, looking at the Constitution and at the statutes, we tried this, and it's obviously not perfect, and we're not, as we talked through things, it was sort of, well, I don't know what the unintended consequences of all of this is, so we are all still mulling this stuff. Frankly, let's get something on paper to start talking for us, so that's what we started with, and we tried to do it in the format that your existing rules, the way you structure existing rules, and hence with the number, whatever the number is, and that's why we tried to do that, so. We looked at the amendment, the constitutional amendment, as being in this section of the Constitution, in section H, where H, now what is H1, but is existing language that talks about state officers and non-judicial folk, and then it, and a code of ethics, and then it adds a new 2 in that same section, right, so legally, so for us, that said, and includes now public officers and public employees, so as opposed to H1 constitutionally, there's arguably a different group of people covered, right? Yeah, because at least constitutionally, forget the statute for a minute, but constitutionally, they've got 2 different things going on there. So that's one thing, but what that said is it didn't override or undo the code of ethics referenced in the Constitution, nor did it undo it in the statute. So we said, well, what portion of the code of ethics, I'm just telling you how we were thinking, so, what portion of the code of ethics might this be putting into, or at least lifting up to the constitutional level? So, that, again, intent to sort of preserve the existing code of ethics, because that's still in 1, and number 2, because it's covering up broader people, what broader section, what portion of it? Well, then you look at the word abuse, and since abuse and misuse are synonyms, we started with the premise that the section in the statutes on misuse of public position is the starting point, because that concept is pretty darn close to that language that's in the Constitution, with some differences, i.e. including who's covered potentially, and the way it's covered. So that led us to do this. So that first, you had to get to a public officer and a public employee definition. We couldn't find or couldn't agree on a good definition of public employee, so that's something we gotta kick around, because it's used a whole bunch of different ways in the statutes.
Yeah, it's all over the code of ethics, but it's not
different
defined
everywhere.
anywhere that
Yeah.
we thought maybe you guys knew of a definition somewhere.
There's
but-
something like, but there's stuff in like retirement plan, I mean, there's stuff in retirement plans, there's stuff in all kinds of things for all different kinds of reasons,
Yeah,
so.
and the reason why we thought it was important to talk about it is because we talked about, you know, when you think about a public employee, you think about, you know, your full-time state worker, or somebody like you, or somebody like a legislator, or somebody like, you know, the elected official. But then when you start thinking about, do you want it, my son, he's, you know, 15 years old, he works Saturdays as an umpire for the Parks and Recreation Department, you know, for $7 an hour. Do we mean for this to apply to him? I mean, I don't really think that's who we're trying to address with this. And, you know, and so there's, you know, and there's other types of individuals who may kind of like have some sort of contractual, you know, there's like, you know, kids who are summer camp
Interns.
counselors and stuff. I mean, I don't think that we wanna.
Unpaid interns, are they employee, I mean, again, depending on the definition you use.
So anyway, that's
we-
something to think
we
about.
went back and forth about what does that mean.
So we left that blank for now. Sorry.
No, no, you're right, so,
So can I ask you, would a public employee, I know in labor law, you would have the interns are considered for pay purposes. I think there's been some case law regarding interns. If they're engaged in work, they're considered employees. So you get into a bit of a sticky problem with them. But I think the measuring stick is clearly the full-time versus part-time, so maybe it's that 32-hour threshold.
well,
Yeah.
that's what the discussion is. We were trying to
Right.
think of all the, well, janitor, I mean, is this intended to get at the cleaning crews and all of those sorts of things, the nurses in the hospitals? I don't know all those answers.
Maybe there's like a difference between like, there's like reporting individuals
Right.
versus non-reporting individuals for purposes of the, you know, financial
Financial-
disclosure. I
those
mean,
employees.
So there's different thresholds about like, I don't wanna call it like who's like more important versus who's less important, but I mean, there's different ways to slice it, and people who are smarter than me about thinking about stuff like this can probably, like you guys, can probably figure that out.
So anyway, so we gotta
yeah,
get some more
that's it.
thought in that, about who this is really, given the nature of what this is, which is talking about who's going to get it, we don't mean her son, we kinda didn't include that, but we just didn't.
Well,
write
you know,
down
he
Rebecca's
probably
kid.
needs to stay on the straight and narrow, but, you know, so if you wanna target him
Okay.
individually.
So anyway, we go, so that's where
Just
we,
put a special umpire category in
a
there.
special umpire, yeah, for the Parks and Rec kids, okay, so, anyway, so we started down that path of, went to the misuses, and started with the misuse of public position. Because this new provision in the Constitution calls out, business relationships, right? Can't get a benefit for your family, I'll say, just spouse, children, employer, and then it goes on to this whole list of business relationships. And because it, carries out the, disproportionate benefit, disproportionate calls to us sounded like need to measure, it's disproportionate, therefore it's gotta be a measurable thing, it's not an illusory thing. We went to, well, economic benefit. So, we looked at it, and then we decided there needed to be a materiality standard for that, and so went to materially greater economic benefit as a portion, as to how you're gonna identify what is disproportionate, otherwise if you can't quantify it in some way, shape, or form. And then, again, because of the focus on business, that to us screamed, and disproportionate, that screamed to us economics, so that's where we went. But backing up on the agency definition, that's right out of 112, and the public officer standard definition is out of the beginning of 112, 312, I think, in both of those definitions. Okay, so we went through that, because it's an abusive office, you shall not abuse the office. We went and decided we looked at the special purpose benefit language there that's in the existing law, and it only talks about votes, but we added actions, because it's the whole office, not just the
So
voting.
you're looking at the voting.
It's more than a voting,
Yeah, it's
But
more
we're
than
talking
that.
about more than just taking votes, we're
Votes.
talking about how you
So-
conduct yourself in office too.
Right, so we added actions to that. And those are the big things, and then on in the last couple of the last, yeah, there is a section at the back, right, that's continued, so saving trees. clearing out those sites.
Would you have
And
any
so-
objection to emissions?
I don't know, what do you mean?
The word omissions,
Yeah,
acts
yeah.
and omissions?
I don't know, I have to
So
think
you're
about that.
looking at,
I have to think about that, because of the way this is drafted.
you, at where it says the size of the class affected by the vote, or action
Action.
or omission, is that what you're?
A failure to act, I mean, you know, clearly an elected official has a duty, and there's a reasonable duty that the citizens expect, you know, they're busy about their business, and they have an expectation, a very well-reasoned expectation that you are there to act on their behalf. And when you fail or purposely fail to act in a reasonable way, and through, or you omit or fail to act in a reasonable fashion, but that would be reasonable way
Yeah, I
to
gotta
act.
think about use of discretion, so I need to think that through, about what that would mean, because you also have the right to take, your legislative, when you're holding a legislative hat,
Right.
you have certain discretion. When you have, you know, there are certain times when you can abstain, for example, and can't abstain, for example, under current law. So I gotta think about how that would lay down next to that. I understand what you're saying.
Well, and I think, correct me if I'm wrong, I'm sorry, hang on just a second, but doesn't the definition of corrupt talk about acts or omissions? Yeah, so I think to the extent that you.
And we use
incorporate
corrupt,
the
and we
term
brought in corrupt.
corruptly, but go ahead, Mr. Atkins, sorry, didn't mean to cut you off.
Well, I mean, when you use the word corrupt, then, you know, you're backing into corrupt intent, which is a state of mind. I mean, you know, that is so wide open,
Well,
difficult to.
There's a lot of law on that, so
Yeah, I know
I guess
there's
that's,
There is
That's
a
what
lot
we
of
said.
law on that, but unfortunately, it's so discretionary. It places a chilling effect upon any citizen would be ill-advised to file a complaint while that sits
Well,
out there and it's so discretionary.
I would disagree with you, but let me go through this. I
Sure.
disagree with you on that, but we'll go through this. So the other thing we took those sections and added actions, and I think there's a question about it. I need to think about, you know, fairly, what omission means, or where it might fit here. And then the last piece of what we proposed here, at least, was to talk about the fact that if you have complied, for example, with the voting conflict law, or if you have complied with all the provisions of the other conflicting employment law, all of those other sections of the code, that if you've done what that says, by definition, you haven't abused it because you followed the existing law on those particular matters of the code of ethics. Again, it didn't override or undo the code of ethics by this provision, so that's where we sort of ended, because going back to what we said last time, which is we've gotta make this some, a standard that people can get, like the citizens and everyday people, especially in the smaller, can understand and do, and understand when they're in the violation and when they're not, and so that was one.
And you don't wanna create a new
Category.
thing that people are gonna have to, I mean, you don't wanna create a new set of standards that people will, you don't wanna play gotcha, where people, you've got a very well-developed body of opinions and advisory opinions and orders, and even judicial opinions that define a lot of these terms that lay out some of the rules of the road, if you will. And, it'd be a shame to do away with that, because there's a lot there to work with that people, for the most, I think a lot of people do understand, those that are trying to do the right thing. And you don't wanna punish those people by, making it more difficult for them to do their job, because that's what we were trying to do.
But wouldn't you, and just in terms of, in the opposing view, I think the citizen view would be is from a citizen's perspective, there was obviously a need to insert this, okay, in the Constitution, which is the strongest place in the law of the land, okay? And so they didn't go to the legislature and say, well, go please insert this in the law, in the statutes. They chose to insert this in the Constitution. They then secondly decided to say, well, we want to have a rule that deals with the topic of disproportionate benefit, which is a new thing. And so it seems to me that they want something different than what we currently have. And so if they wanted to go with what we currently have, there would be no need for this. And so certainly when you look at the CRC itself, it is a great deliberative body. that great deliberative body would have had ample time to vet this. There were committee meetings, there was a vetting process, there was the full CRC. And so this was a significant point of discussion. And so had it not been necessary to move in this direction, this no doubt through that vetting process of that great deliberative body would have been essentially eliminated as this is duplicative, it is unnecessary, let's dispense with it because, as you pointed out, we already have this great body of case law. This is unnecessary, we don't need to do this.
Well, in fact, the CRC in their deliberations, when this issue came up, and people asked about, well, what does this term disproportionate benefit mean? The CRC members themselves hearkened to that great body of case law, and in fact expressly said, we have case law that defines this term, and the Commission on Ethics can use that when they develop their rules and reference that, and it shouldn't be too hard to do when they do their rulemaking. I'm paraphrasing, but that's about what they said when they were deliberating this on the floor. So I think they recognized that they had something to work with already.
Okay, so if in fact the case law is there, and if in fact, but you know, the reality is, my point is that they chose to put it here. And they chose to put it here for a reason. And so then the question then becomes, I think probably from the citizen perspective, is disproportionate benefit obviously means something different to me than it does to you. And so
Interestingly enough, the legislators are included in this provision. So that's different.
So when you start to kind of weigh out, what does it mean? And I think, what does it mean? I think you've got to look at, what does disproportionate benefit look like? And so when you look at, and that's was the original, my comments was to point out, what does it look like? Well, and some of you probably said, no, that doesn't seem to me to be a disproportionate benefit. And some of you may have said, no, that does look like the disproportionate benefit. So for some of you, it may have rung true. For some of you, it may have not have rung true. But the reality is that there's examples, and if we go through the examples of what sort of rings true and what doesn't ring true as a disproportionate benefit, we get to a conclusion point of saying, here's what it is. Because we've got to define, what is it? Exactly what is it in a reasonable way, within a certain degree of assurance, this is what it is, because your definition is going to have to capture that. Otherwise, the definition is arbitrary, capricious, it's broad, unbridled. It becomes difficult to capture a definition that then gets past the rulemaking process. It doesn't pass muster.
Well, we're all here trying to figure out what disproportionate benefit is,
Well,
so that's.
but it's not a term, and I wanna say this, because it's not a term in a vacuum, because it has to be a public officer or a public employee abusing a position to gain a disproportionate benefit. It's not, is there one? It's did it first, is it a public officer or employee? Second, is the official position been abused, whatever that means, but that's what we're talking, what we've talked about with. And then three, to get a disproportionate benefit, and oh, by the way, for these, in this particular way, for this person, their spouse, those business interests, et cetera. So we have that as the overlay, which again is a part of, but not totally the same as misuse of office. And so it is a one-off of misuse of office just by the terms used. So it's not just, is there one in the abstract, it's, was there a public officer or employee who's covered by this provision involved? Was the official position involved? And was it abused to get that? And then you have to decide whether the benefit is just a benefit or it's disproportionate or whatever. So that's just the word
Sequence, right?
in language, don't grab the sentence, right?
Right.
So.
No, I don't disagree with you. But I think it has to be, we have to be able to define it in a way that says, here's, in terms of just the application of that definition, because this is definitional, all right? This will be applied in a uniform, consistent manner across the board in all circumstances, as it relates to public employees, public officials, these public servants, and they have to be able to clearly see with clarity, plain meaning, that this is.
So talking about a little bit more about bidding, one of the things we kicked around, for example, was what would it look like? So if there's a competitive bid out there, right, you have no issue with the person's, there's other law that would govern whether you can vote on that or not already, right? There is some existing law. about voting them, but we were kicking around, for example, if you're on a rotational contract, so the counties, for example, not to pick on the counties, they hire bond firms, bond lawyers, and they usually list 6 or 8 of 6 of them on a rotation, and then the first, once they're deemed qualified and whatever, then the first bond deal goes to the first firm, and then whenever the next one, if any, goes to the second firm, and that's just a rotation, and then you jump to the bottom of the list. That's how they do that work, in many cases, not every case, and not all the time, but there's rotational contracts like that. Does that, if a county commissioner is a member of one of the firms that comes up on the rotation, is that an issue? I mean, I think we would say they would have, when the contract is awarded, they may abstain from voting under the voting conflict section of the law,
It
right?
becomes a benefit. It becomes a disproportionate benefit
Yeah,
because it's not competitively bid, so.
Yeah,
What
but
about the
that's the
influence of
system.
this position?
Well, but it's rotational, you don't pick when you don't pick what bond deal you get, you're just on the list, because you're qualified.
It had previously gone through a process.
A qualification process.
So-
And so, for example, I'm just making this as this is all one example kind of thing, and it was our sense that voting conflicts would pick up any vote on that contract, they would have to abstain. But I don't think simply by, one, did they abuse their office to do that? No, they were just a member of a firm, that they may not even practice in that field, I mean, I don't know, right? Especially some of the mega firms, so, I don't, and it's not me, and we're not on those, but I'm so quickly saying.
Certainly personally, I would oppose that.
Yeah.
Okay, and from my standpoint, I think chapter 287.001 crafts and outlines the legislative intent regarding competitive bid. And so, the public officers who seek to serve in public service need to focus on that public service.
And I'm pretty sure it doesn't cover these services.
And so, the reality of it is that, competitive bid is a good thing.
Mhm.
And there's no question that it is in the broad public interest of that county commission to seek a competitive bid process. So the county commission, if they have to seek a competitive, structure a competitive bid process among the bond firms, they can structure that any way they want. But the truth is that to somehow dismiss the competitive bid nature, I think compromises I don't know how you get around the disproportionate
Can I ask you
benefit
a
issue.
question? Would you object to the firm being awarded through the process, or do you object to the commissioner voting?
I would object to the firm being awarded in the process. I think if it's a competitive process, I think the commissioner should vote. I think they should have a right to vote, and I think they should participate. I think they have a duty to cast their vote and express their view on it. If they think ethically they need to abstain based on personal basis, that they should abstain, I think that's a personal choice for them to abstain. I don't think they should stand up and walk out of the room in order to sway a vote. I think that's an omission. When we talk about omissions, when people decide, I'm gonna tilt the vote this afternoon, I'm just gonna get up and walk out and get a cup of coffee, and I'm going to change the vote by my absence.
I would
Or-
argue that that's an action, but.
It's
but
a-
Well, and I would argue
It's an
that's not,
omission,
if that's an omission, then I can't agree to put omission here, because
Well, they omitted to
But
vote.
but then you're getting to the intent of why they walk out of the room, and
Well, I don't
we're
know.
not gonna,
I don't
well.
know.
But
I don't know,
it sounds like
I don't know why,
as long as
they
there's
had a
a
duty to walk in
process.
there and vote and cast their vote on behalf of, I expected them to go in there and vote.
But it sounds to me like as long as you're satisfied, as long as there's a public and open process to select the
Sure.
contract.
Sure, I think if there's a competitive bid process, I think
Now
that
you
then
must-
extinguishes the notion that there's a disproportionate benefit at work. And they have not, I think that guards them against the allegation that there's a disproportionate benefit that's being conveyed.
Do you think every service?
I think that's your
needs to
safe
be-
harbor.
Do you think every service should be competitively bid?
Absolutely.
Let
And
me
so,
ask you if I might, this is Chris Anderson. Mr. Atkins, I think what she's getting at there is there's a lot of mechanisms in chapter 287, and competitive bid is one of them, and then there's request for qualifications, request for proposals.
Invitations to
Typically,
negotiate.
bidding is like for bags of concrete, and professional services are, usually a different mechanism. It's laid out in 287, but strictly speaking, it's not competitive bidding to the lowest or best bidder. would you think that everything, even professional services, have to
So-
be sort of like bags of concrete?
So the public interest is well served when people have an opportunity to compete for that piece of the public's business. And so, one of the things that people have concerns about is those relationships sometimes become very entrenched. Others cannot have a chance to compete for those relationships or agreements. And whether it's the lawn contract at the local school system, or whether it's whatever it might be, because, they simply have decided not to put it out for competitive bid. And so the truth is that the competitive bid process gives those small business owners, and I can tell you, small business is the backbone that drives our economy. It is the backbone of innovation, and the reality is that the second we lose sight of that in government is problematic. And these are tax dollars. And so if there's a local law firm in my county that wants desperately to have the opportunity to compete for that piece, now, if they can't meet the qualification criteria that the county set out, well, they had the shot. But they had an opportunity to compete now on an even playing field. But if they couldn't rise to the threshold that the county set, then they get another window. But if the county wants to say, look, this is a 3-year contract, or whatever period they want to set, that's all up to them. They can decide how they want to proceed with that. But the truth is that when you have a competitive bid process, it restores public confidence that we have a process that you can have confidence in, and that this is coming back around. And at that point, I think you've created the safe harbor for the public servant, for the public official to say, that is my safe harbor. There is no disproportionate benefit here to anyone. We have a competitive bid process, and I'm going to rely upon that competitive bid process to ensure there is no disproportionate benefit being granted to any single person in this process. Everybody can come, everybody's welcome, everybody can be joined into this process.
Can I ask Mr. Shea a question? Just because the intriguing thing about your proposal to me is it almost doesn't, it sort of defines disproportionate benefit, but it really says, if I'm reading it right, maybe I'm not, so straighten me out here, that really you're gonna find it on a case-by-case basis. And you've given a bunch of questions or factors that should be considered, and, we've got the fact that is that, am I reading that right? Is that, in other words, because your disproportionate benefit can't be defined as a disproportionate benefit in your first sentence. That's the tough, the confusing part to me, but then I get to the end and I go, okay, so what you're really saying is whether there is a disproportionate benefit is really made on, and this, it could be under whatever criteria or questions, is that, so the rule really doesn't define it, because you can't define it with itself.
No, the rule's not defining it. Guess that's why we're here, to find out disproportionate benefit. And what I've went through
Yeah.
to understand the language part of it.
So I think
Go ahead.
what he's saying is a determination of whether a disproportion exists shall be made through the investigation of the facts. And so I think, obviously, once the commission has conducted what appears to be is he's outlined a set of criteria, and based upon the investigation, the disproportionate benefit is determined based upon the investigation and the fact pattern. So if the fact pattern bears it out, and it's a case-by-case basis. And so that way, nobody is caught into the vortex of this, this very cumbersome definition. But I think, and I think, the intent of disproportionate benefit deals with, I believe, how when you examine, and I understand why government likes to do business the way they do, there's convenience, there's a perception of economies of scale, but then from the citizen's perspective, they have issues with it, okay? There are people in chambers of commerce. I've had I've had people complain to me, they've somehow, because, they've said, well, I can't compete, I can't be engaged, there's no option for me to be able to seek after these governmental contracts. There's no way for me to play or to participate in this process, I'm locked out. That is a common perception. You have to know that. The government is for government. Government is for the special class of people that are tightly aligned with those interests. And unfortunately for the small business or the innovator or the college graduate who wants to take advantage of the great opportunity that Florida is to innovate and to express yourself as an innovator, as a world-class person, they unfortunately feel that they can't compete. They can't come to the board table and say, look, I can do this better. I can do this at less expense, and I can help you find a better way. And so they don't feel like that opportunity exists. I can tell you, I'm building a new building right now. I had to force my general contractor to get away from his old relationships, and after I forced him to look at some new players, he found some new subcontractors that he got excited about. But it was like pulling teeth. He was gnashing at teeth, trying to pull away from his old subs, because he likes them. He's got relationships with them. But once he found out there were some new players on the market that would do it for less money, he suddenly found new relationships that were more prosperous to the project's interest. That's when things changed.
I guess to
Okay.
Rebecca's point earlier, we know what the existing case law is on all of that, so it's important for electeds and staff to understand that if you comply with the existing statutes, then you should be determined to have met your burden. So I wanna make sure that when we're talking about this new category of ethical standards, that we're not creating a parallel path for a potential violation. And if this is something that is outside of those existing statutes, we need to be very specific in the rule so that people know that they are about to violate the Constitution. So that would be, that's why we looked so closely at the language in the constitutional provision. We did a pretty heavy analysis of the language just to make sure that we know what this new ethical standard is. So that's what concerns me when we're getting away from existing legislative action that we should be able to rely on, and how that interplays on that.
So-
Rebecca, you've been trying to get
Wait,
over.
I just want to ask a question, let her clarify. So you're saying that if there's no voting conflict, there's no misuse, there's no financial disclosure violation, then there wouldn't be a violation of the new constitutional
Or if you've
provision?
complied
That's
with.
what- If you've complied with all of the other statutes, the disproportionate benefit and the intent associated.
Or to the extent
That's
that
your
there's a
position.
difference,
Okay.
it needs to be very clear
Right.
in the
Okay, or if
rule.
there is
Yes.
a difference. Okay, I'm sorry.
Oh, I had a question for you, Mr. Slade, if I may. On your itemization, number 4, I just had a question about what that meant, where it says, did the public officer utilize his or her position to seek a legal opinion or advisory opinion to favor his or her use of public resources to create a special gain or benefit for a family member or an employer? And maybe I'm not reading that right, but what I often see is that, public officers or attorneys will often request an opinion from the Ethics Commission or from the Attorney General, for example. But I guess in this example, it's probably would be the Ethics Commission to determine whether or not they are on okay footing so that they don't run afoul of the code.
At the legal expense of the taxpayers.
Well, because they
Always.
don't wanna violate
But
the,
at the legal expense of the taxpayers
Well-
for your own personal business of your spouse.
I mean, Yeah, I mean, if you as an elected, as a public employee aren't, you know, think that something, you know, you're faced with an issue and you're thinking there's a potential issue here and you need to know whether or not it is, you know, it is
It is
legal or not under the ethics code. I mean, it is something that you're allowed to do by law. I mean, and so, so you're, that's.
Agree, is allowed by law to seek an opinion from the Ethics Commission
Yes, sir.
to make sure he's not, or she is not, in violation
Right.
of the law. But
Right.
my concern is about legal aspects of misusing, abusing your position, using government funds.
So that would
for
now be-
legal expense.
So that would now-
Disproportionate benefit of using that firm.
So when you look at this opinion, okay, you had the superintendent of schools request an opinion of this commission. And this opinion essentially says, if you want to contract with your stepson, because the term stepson is not properly defined in statute, you can give all the roofing contracts from the Nassau County school system to your stepson, who owns a roofing contracting company, and you can do a single source contract.
Okay.
So, no problemo. So what happens is, as a result of the advisory opinion,
Right.
you've now created a safe harbor.
Okay, I'm not
So then-
expressing
so
an
then-
opinion whether
Right,
it's
right.
good, bad, or
So-
otherwise. I
so-
just wanna make sure I
so the-
understand.
so-
Wait, can I finish, please?
Sure.
I just wanna make sure I understand. I'm not expressing an opinion about whether it's good, bad, or otherwise. I just wanna make sure I understand that what you're proposing is that the current avenue under current law that would allow a public official or an employee to request an opinion of the Commission on Ethics, an advisory opinion, would be a factor that would now be, I guess, a presumption, if you will, that they would be obtaining a disproportionate benefit. Is that what I understand? Okay.
Yes.
Okay, thank you.
If it translates into a disproportionate benefit.
Okay, thanks.
Does it translate into a disproportionate benefit or
I
not?
just wanna make sure I was reading it right. Thanks.
If it doesn't translate into disproportionate benefit, then there's not. Like with the t-shirt sales opinion, the t-shirt sales are clearly not appropriate, right? You couldn't have the teacher selling t-shirts inside the schools. If they went to another school district outside the school district, that was fine. But the reality was, if you sold t-shirts inside the school district, you couldn't do that. That was a problem. And so the reality is does it then translate into a disproportionate benefit? Does it mature into that? So then obtaining the opinion becomes, if they act on it. So obtaining the opinion in and of itself, I don't think becomes problematic. It's a matter of what you do with it. And if it then translates or then matures into an act or a mission or whatever you do with it, then I think you should be concerned.
It would also pick up the AG, yeah.
And so-
Anything else? Oh, I'm sorry, go ahead.
So I think, you know, the
So it would also go to, sounds right, go ahead.
So I think the discussion, the discussion has to be about looking at, you know, and I appreciate your draft, that was very helpful, but I think the discussion has to be, what is the acts, the omissions, and again, I think recognizing public officials have to continue to be able to run their businesses, they have to be able to continue, you know, seeking to do business. I would have no problem with the county commissioner who is on that bond trading firm. If they are on the list for the county that's right next door, the county that is next, in the county next door, and they don't serve on that county commission, if they're on the list, the rotating list, I don't think there is any problem. Because they don't serve on that county commission, they don't serve on that elected body. But I do think it's a problem when you serve on that county commission, and if you are obtaining no bid contracts with the local school board, or if you're obtaining local, because there is an absolute perception, you have broad influence, you're a well-known public figure inside that elected jurisdiction. And so the reality is let's say you are elected up here in North Florida, but let's say you are doing business in South Florida. Well, nobody knows you in South Florida, or nobody knows you in Central Florida. well, then I think that's perfectly fine. You know, you certainly have a right to pursue your proprietary interests as a business person, you know, and be on whatever law firm you want and conduct business wherever you want. But the truth is that, you know, if you are on a board commission and you're serving in a public office somewhere, then I think you've got, and there's a definite conflict, you know, that starts to arise when you are obtaining, no bid contracts and other types of special benefit. And again, that word special benefit arises, I think, and it ties directly to disproportionate benefit. And I think that's the nature of disproportionate benefit. As you get into that whole, you start stepping away from the competitive bid statute. And I think.
Can I just, two points. I just want to reiterate, under Cheryl's hypothetical, it was like qualifications, so it was not, that's something that we need to confirm. And then my second point would be that the misuse of office does go to, in certain elements, this relationship and using your relationships to gain a benefit. So this is to my point about where does existing law line up with this piece of the Constitution.
Is it a problem for you to have a county commissioner obtaining no bid contracts with boards and commissions in the jurisdiction in which they serve?
Define no bid. Define no bid. We're not agreeing on that definition here.
No
I mean, that's the
bid.
confusion here.
In other words, they're being awarded, nobody else is allowed to bid on that contract. It's going directly to your county commissioner.
That's not the hypothetical that Cheryl presented.
I'm telling you, that's what's happening.
Oh.
And that's happening with port commissioners, it's happening.
Right, no, but I just wanna make it clear that we're not advocating for anything.
Yeah, I mean, the hypothetical I viewed is not a no, it's not a no bid, it's a process that's set out. And again, not everywhere, so it was just the one that came to mind, so.
So what would be wrong with having a competitive bid process and having a 3-year agreement?
Well,
That's-
y'all,
yeah.
y'all, we're not here to like
No.
revise chapter 287. We're here to
Right.
deal with
No.
this constitutional provision.
Right,
I mean,
but you have to
so
decide
if
what
your
it is.
issue is with chapter
No, no.
287, then take it to the legislature.
Not at all. It's what is a disproportionate benefit? And,
Well,
and.
I know, but all we're
doing.
doing is talking
Right.
about bidding in
No,
287.
because a special benefit, a disproportionate benefit arises and it ties to your business interest. And so you're going to obtain a disproportionate benefit when you are obtaining no bid contracts, no
Already
bid
covered.
agreements.
Okay,
There's a direct line to that,
gotcha.
that relates to disproportionate benefit. You can't sort of step away from that. Or if you can, I'd like to know how you legally do that.
I don't know.
Oh, I'm not an attorney, but I don't know how you did that.
I appreciate all the discussion and debate. Anybody else have anything they wanna add? I'm happy to stay here as long as you want, but I know everybody has things to do. All right,
Well, I just want to close it out then. As stated in that notice of development of rulemaking, the next workshop, our rule development for Rule 34-18.001 will be held on March 15th at 10 a.m. right here in the conference room at the Ethics Commission. The time is now 11:09. It's Friday, February 8th, 2019. The second workshop for Rule 34-18.001 is adjourned. Thank you.
Thank you.
thank you, Greg.
What time will it be?
10 a.m.
10 a.m.?
10 a.m. Thank you for not making it 8.
You're not even making it 9.
Yeah.
Senator from
Callahan.
Yeah.
Did y'all drive over this morning or
That's
not?
all I have.
Yeah, I drove over.